Hey everyone, attorney Andrew Bethel here, back to talk about a trend that's becoming all too common, the dangers of online fill-in-the-blank estate plans. These one-size-fits-all documents are popular, no doubt, and they do promise quick, easy, and cheap solutions, but here's the reality. They're often riddled with issues that end up costing families much more down the road. So before you hit print on that online trust form, listen up. I'll be sharing some common pitfalls I've seen in these documents and explain why a custom, professionally prepared estate plan is almost always a better investment. And as always, if you find this helpful, please like, subscribe, and share the video with anyone who's considering an online estate plan. Let's dive in. Let's start with one of the biggest issues: no provisions for trustee vacancy. A trust needs a trustee to be valid, plain and simple. But what happens if your trustee steps down, passes away, or becomes unable to serve? Many online trusts don't address this crucial what-if scenario. When there's no trustee in place and no backup plan, your family might have to go to court to get a new trustee appointed, which defeats the whole purpose of having a trust in the first place. This could mean months of delay, thousands in extra costs, and a whole lot of stress that could have been avoided with a properly drafted estate plan. Another issue I see constantly is no contingent beneficiaries. Your trust might name your primary beneficiaries, but what if one of them predeceases you or decides not to accept the inheritance? If there's no contingent beneficiary named, your family will be left guessing, or worse, the assets might end up in probate court. Probate is costly and time-consuming, but it's entirely avoidable. A professionally drafted trust always includes contingent beneficiaries, covering all bases so that your assets pass smoothly to the people you care about most, no matter what. Here's another thing that might surprise you. The trust name itself is often missing or inconsistent. I've seen trusts where the name changes from page to page or doesn't appear at all. This seems minor, but in legal terms, it's a huge problem. If your trust's name isn't clear or consistent, it will be challenging to prove ownership of the trust assets, potentially leading to disputes or challenges in administering the trust, meaning we're back in court. A clear, consistent trust name may seem like a small detail, but it's one of those critical things that can prevent major headaches later on. A custom trust typically includes important family history and background. Why is that? Because it provides context, ensuring your intentions are clear. I've seen cases where an online form didn't capture the nuances of family relationships, leading to confusion, disputes, and hurt feelings after a loved one's passing. The personal story behind the estate plan matters. Without it, a generic trust can create ambiguity about who is included, who is not, and why certain decisions were made. That's why we include details in a custom plan that clarify the big picture and eliminates guesswork for future generations. Let's talk about no contest clauses. These clauses are powerful tools for preventing legal battles. In an online form, no contest clauses are often missing or just so generic they don't do much good. Without a no contest clause, any disgruntled family member could decide to challenge the trust in court, dragging out the process and causing potential rifts within the family. A well-crafted no contest clause can discourage frivolous challenges and ensure that your wishes are respected without unnecessary drama. It can also help the trust recoup the cost from defending itself from the frivolous suit in the first place. One of the most confusing aspects I've come across is whether the trust remains amendable after one trustor passes away. Many online trusts fail to specify what happens if one of the trust creators dies. Can the surviving spouse make changes, or is the trust now set in stone? Without clear language on this, your family might be left with no flexibility when circumstances change. In professionally drafted trusts, we spell out whether the trust can still be amended and under what conditions, ensuring that your estate plan remains adaptable even after a loss, and so that we can avoid paying unnecessary taxes from date of death onward. And now for the biggest disaster I've seen: poorly written or missing distribution clauses. Believe it or not, I've seen trusts from online providers that vaguely state assets are in trust for the benefit of certain people, but then they refer to beneficiaries without defining who those beneficiaries are. If a term is undefined, that's a recipe for confusion and essentially confirmed legal battles. In one case, I had to step in and help a family interpret what should have been a clear distribution plan. Without a well-defined term and clear instructions, your beneficiaries might end up in court spending thousands of dollars to figure out what the trust was actually supposed to do in the first place. All of these issues point to one big problem with online fill-in-the-blank trusts. They're not tailored to you and your family's unique needs. They're designed to be fast, easy, and cheap. But in the long run, they often end up being more expensive, more complicated, and ultimately more stressful. Remember, a trust is meant to provide peace of mind. Skimping on this crucial step of your legacy by using a one-size-fits-all template can leave your loved ones in a mess with more expenses. Investing in a professional, custom-drafted trust may cost a little more upfront, but it saves your family from paying much more in the future. This holds true for working with individuals or companies who market themselves as professionals, yet they simply purchase these online forms and repackage them to you without changing any of the details or even understanding what's in there in the first place because they don't even read it. And believe it or not, the same holds true for attorneys as well. If you meet with an estate planning attorney, be sure to ask them questions about the process, their procedures, and ultimately the documents themselves. You're there for a service, and these documents are there to protect your estate. Doesn't it make sense to ensure that you're comfortable, that you really will protect you and your family? Just some food for thought. Thank you for watching. If you found this helpful, please be sure to like, subscribe, and share the video with anyone who you know is planning on making their own estate plan. And as always, leave any questions or topics in the comments below. I'm attorney Andrew Bethel, and I'll see you at our next meeting.